Hi, thanks for joining me today. Welcome to today's webinar, Estate Planning Basics for Principles of Preserving Wealth, brought to you by Royal Wealth Management. This is part of a series of webinars you can attend monthly on the second Tuesday of every month. We're holding them starting at 11:30 Mountain Standard Time. So at Royal Wealth Management, we understand the significance of supporting your financial goals and fostering a culture of financial wellness. And these monthly webinars are part of what we do to show our commitment to helping you pursue financial well-being by equipping you with the tools and knowledge necessary to make informed financial decisions. Before we get started, I'd like to introduce myself. My name is Darren Royal. I'm the president and owner of Royal Wealth Management. My firm's been helping clients pursue their financial goals for over 20 years. Royal Wealth Management was founded to assist clients in every aspect of their financial lives. We strive to help create financial stability and security for each one of our clients. We want to provide people with the tools that can help them make informed decisions. So we offer informational material on a wide range of topics because we understand that individuals have a diverse financial needs. If you have any questions during the course of this presentation, we'll provide additional instructions at the end on how to get your questions answered. Keep in mind that the information in this material is not intended as investment, tax, or legal advice, and please consult a professional for specific information regarding your individual situation. With all that out of the way, let's get started. So the first question I want to ask is, what is an estate plan? And simply put, it's a map of how you want your personal and financial affairs to be handled in case of incapacity or death, and the subsequent implementation of strategies that can help fulfill those objectives. And the second question you may be asking is, who needs an estate plan? And the chances are you do, or everybody out there probably needs some sort of estate plan. You may think that estate planning is just for the wealthy, but it's not. In fact, an estate plan may actually be more important if you have a smaller estate, because your financial expenses will have a much greater impact on your estate, and there's a much greater possibility that your loved ones could suffer from a lack of financial resources. The fact is, without an estate plan, you can't control what happens to your property if you die or become incapacitated. And generally, people create estate plans because they want that control. They also want to make sure that their wishes are clear in order to avoid family disputes. In addition, they care about preserving their property for their loved ones and want to make sure that their loved ones are properly provided for. And you may especially need an estate plan if one of the following fits your current situation. Your spouse isn't comfortable with financial matters, so you want somebody else to help to direct that if you can't make those decisions. You have minor children. Again, you want to make sure that they're properly taken care of, and you want them in the hands of somebody that you want to take care of them, and maybe not who the court appoints. If your net worth exceeds the federal transfer tax exclusion amount of $13 million, or if less, your estate's exemption amount. Each state may have a different amount than that. And these numbers can change, keep in mind too, which we'll discuss a little bit later. You own property in one or more states because each state may have their own situation out there, or laws that you have to follow when it comes to finalizing a state. If you own property outside of one state, you want to make sure that you have something written down for that. Financial privacy is a concern. We'll talk about that a little bit later and how you can avoid that. And if you own a business, you probably want to have an estate plan as well to make sure that the business is divided up properly amongst your heirs if something happens to you, or that the business can continue if you're incapacitated. There's estate planning concepts that we'll be looking at today. We'll talk about planning for incapacity first, briefly discussing both the healthcare issues and property management issues. Then we're going to talk about planning for death, focusing on wills and probate, tax basics, lifetime gifting. We'll talk about the use of trusts and life insurance in there. Incapacity describes a condition in which you are legally unable to make your own decisions. And we're talking about planning for incapacity first, because incapacity could happen to anyone at any time. Think about it for a moment. What would happen, for example, if you were to become a victim of an accident that puts you in a coma for several months? How would your doctor know what medical treatments you would want or not want if you can't speak for yourself? How would your personal business be transacted if no one is authorized to sign documents for you? What could happen is this. Someone would have to go to court and get legal permission to do things for you. And that person, who's called a guardian and is usually a close family member, such as a spouse or child, would have to go back to court every time permission is needed. As you can imagine, this might be quite burdensome to the guardian. Further, without any prepared instructions from you, your guardian might make decisions that would be different from what you would have decided. So let's talk about healthcare directives first. You can leave instructions about the medical care you would want if conditions were such that you couldn't express your own wishes. There are 3 different ways to do this: with a living will, a durable power of attorney for healthcare, which is referred to in some states as a healthcare proxy, and a do not resuscitate order, or a DNR, you may know it as. A living will is a document that lists the types of medical treatment you would want or not want under particular circumstances. For example, your living will might state that you would not want life support if you fell into a persistent vegetative state. With a living will, you'll have to think about all possible scenarios where you would want a specific action to be taken, and then put your wishes in writing so that the reader will clearly understand them. A durable power of attorney for healthcare, or healthcare proxy, lets one or more family members or other trusted individuals, who are called agents, make medical care decisions for you. Unlike a living will with this type of healthcare directive, you don't need to envision specific circumstances. You simply grant authority to the agent or agents to make decisions for you. A do not resuscitate order is used for a different purpose. Let's say that you're in the hospital lingering and suffering with terminal illness, and you don't want the hospital staff to take life-saving measures if you suddenly go into cardiac or respiratory arrest. To make sure your wishes are carried out, you may be able to get your doctor to issue a DNR. A DNR is a legal form signed by both you and your doctor that's posted by your bed to give staff members the permission they need to carry out your wishes. But be careful if you're using a DNR. Some states require their DNR form, and some states require one DNR form if you're in the hospital and a different DNR form if you're in a nursing home. Now let's take a look at some property management tools. There are 3 ways that you can have your financial affairs taken care of in the event you become incapacitated. You can arrange to own property jointly, appoint an agent using a durable power of attorney, or create and put the property in a living trust and name someone to take over the management of the trust if something happens to you. Granting joint ownership of property to another person allows that person to have the same access to the property as you do. If you become incapacitated, your joint owner simply acts instead. For example, if you or your spouse have a joint checking account, each of you can make deposits or write checks. So if you were to go into a coma, your spouse would still be able to make the mortgage payments on time. A durable power of attorney lets you name family members or other trusted individuals to make financial decisions or transact business on your behalf, just like with the durable power of attorney for healthcare. In addition to joint ownership and a durable power of attorney, using a living trust is another common strategy. We'll talk in more detail about trusts later, but for now, just know that a living trust can be used in planning for incapacity because someone called the successor trustee can step into your shoes to manage the property in the trust if something should happen. All of us make plans that are based on possibility that specific events may occur, right? Many of us carry more than a minimum required amount of auto insurance because we recognize the possibility that financial loss could result from an accident. Since it is 100% certain that each of us is going to die at some point, you might think that everyone would have an estate plan. The fact is, though, that is just not the case. What would happen if you die with no estate plan? If you own property jointly, that property may pass automatically to joint owner upon your death. If you have an IRA or retirement plan, or you own life insurance, funds may pass automatically to your designated beneficiaries when you die. Let me point out, it's real important to make sure that your beneficiaries are up to date, because in some states, beneficiaries may even supersede wills. Similarly, property held in a trust may pass automatically to a designated beneficiary. In general, however, property will pass according to state Intestacy laws. These laws govern the disposition of property when someone dies without a will or with a will that doesn't account for a portion of his or her estate. So let's say you die leaving $5,000 in a savings account. Who does the money go to? Without instructions from you, the money would go to the person or people that your state's intestacy laws say it should go to. Intestacy laws vary from state to state, but here you see a typical pattern of distribution. 50% of the property goes to the spouse and 50% to the children. Remember, it may be different in your particular state. The biggest issue with intestacy is the fact that the actual wishes are irrelevant. Let's assume that you live in a state that has intestacy laws pattern as shown in the slide. Without an estate plan, regardless of your actual wishes, for example, let's say that you wanted all your property to go to your spouse and none to the children currently, your estate would be divided between your spouse and your children regardless. There are many potential problems with allowing your property to pass by intestacy. For example, the distribution pattern imposed by your state's intestacy laws could result in disputes among your heirs and higher overall taxes due. Intestacy can be particularly problematic for unmarried couples, since intestacy laws generally will not include an unmarried partner in the distribution of property. There's a very simple way to avoid intestacy, though. You can create a will. A will is probably the most vital piece of everyone's estate plan. A will is a legal document in which you direct how your property will be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for your minor children. You can also create a trust in your will. You can use your will to accomplish other estate planning goals as well, such as tax planning. To be valid, though, your will must be in writing and signed by you. Your signature must also be witnessed, although the number of witnesses required varies from state to state. These requirements are important because if you aren't careful, your will may be invalid. So see an estate planning attorney to take care of this for you and avoid any do-it-yourself solutions. Now, there's one big consideration to having a will for some people, and that's the fact that wills generally have to go through a process known as probate, and we'll take a closer look at the probate process next. Most wills have to be probated, and the rules vary from state to state, but in some states, smaller estates are exempt from probate or qualify for an expedited process. What does probate entail? Probate starts with someone filing the will with the probate court, which will then oversee the estate settlement process. Usually the person named as the executor in the will does this. Once the will is filed with the court and validated, the executor can go about the business of settling the estate. This means collecting monies owed to the person who died, such as wages, paying any outstanding bills that are due, filing final income taxes and estate tax returns if necessary, and then distributing the remaining property out to the rightful heirs. Usually everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending on the size of the estate, as long as the executor does what needs to be done in a timely fashion and there are no family squabbles. Nevertheless, some people may want to avoid this process, and let's take a look at why this is. Before we look at the reasons why you might want to avoid probate, let's review the positive aspects of probate. For most estates, there's usually little reason to avoid probate. The actual time and cost involved are modest, and it just doesn't make sense to plan around it. And there are actually a couple of benefits from probate. Because the court supervises the process, you have some assurance that your wishes will be abided by. And if family squabbles should arise, the court can step in and help settle them. Further, probate offers some protection against creditors. As part of the probate process, creditors are notified to make their claims against the estate in a timely manner. If they don't, it becomes much more difficult for them to make their claims later. But for some complex estates, probate can be more burdensome, taking up to 2 or more years to complete. This could tie up property that your family may need immediately and also increase the costs that can arise, such as executor fees, attorney fees, and insurance costs. And if you have real estate in more than one state, for example, if you own a summer home in Maine and a winter home in Florida, your executor will have to file in each state where the property is located. This is referred to as ancillary probate. Additionally, wills and other documents submitted for probate become part of the public record, which may be undesirable if you and your family members have privacy concerns. If any of these issues are a concern to you, an estate plan can be designed to limit the assets that pass through probate or to avoid probate altogether. The major ways property is passed outside of probate are by owning property jointly with rights of survivorship, by ensuring that beneficiary designation forms are completed for those types of assets that allow them, such as IRAs, retirement accounts, and life insurance, and by putting property in a trust. Another one is lifetime gifts. Now let's switch gears a little bit and talk about estate tax. There's three types of federal taxes that may be imposed when property is transferred from one person to another, either during life or at death, referred to collectively as transfer taxes. These taxes are gift tax, the estate tax, and the generation skipping transfer tax. We're going to discuss transfer taxes on the federal level only, but be aware that the individual states may also impose their own transfer taxes, and they generally affect smaller estates. It's important for you to get more information on transfer taxes imposed by your particular state. If you, the donor, transfer property to another person, the donee, during life, the transfer may be subject to gift tax. The reason there's a gift tax is to prevent individuals from avoiding the estate tax by giving all their property away before they die. The gift tax doesn't apply to every lifetime gift, though. For example, in 2024, you can give up to $18,000 to many individuals as you want, gift tax free under the annual gift tax exclusion. By the way, that $18,000 figure is 2024, but the annual gift tax exclusion is indexed for inflation, may change in future years. In addition, each individual has a lifetime exclusion from all transfers that gifts in your estate combined. That amount currently is $13,610,000 in 2024. That's the largest exclusion that's ever been allowed in history of the federal gift and estate tax. And keep in mind, these do change. In fact, they were changed again just this past year and rose. But the last time they were, in 2025, I believe, will be in cut in half. When property is transferred at death, it is generally subject to estate tax. This is true whether or not the property goes through probate. For example, even though funds in an IRA pass by virtue of beneficiary designation, the funds are still potentially subject to estate tax. As with the gift tax, there are exceptions to the estate tax. For example, property that you leave to your spouse will generally not be subject to estate tax because there's a full deduction allowed for marital transfers. A similar deduction is available for property left to a charity. In addition, as discussed on the previous slide, each individual has a lifetime exclusion from gifts and estate tax combined. That amount is $13,610,000 in 2024. To be clear, there is one $13,610,000 exclusion that covers both gift and estate taxes. Any portion of the exclusion you use for gifts will not be available for your estate. There's a new feature of lifetime exclusion that is potentially very important to married couples. That exclusion is portable. That means that any portion of the exclusion that is not used by deceased spouse can be transferred to the surviving spouse. In prior years, that was not the case. Married couples with larger estates had to do what is referred to as a bypass planning, typically using a trust. But in 2011 and later years, such planning will not be necessary for transfer tax purposes, although there are other good reasons to use the bypass trust. But that is more than we can discuss today. We're going to just keep moving on here. Suffice it to say, together a married couple can pass along $27,220,000 tax-free as long as the estate of the deceased spouse makes the proper election on the estate tax return. The third piece of transfer tax system that we will need to mention is a generation skipping tax transfer. In the world of estate planning, someone who is more than one generation below you, for example, a grandchild or a great-grandchild, is referred to as a skip person. If property is transferred either during life or at death to a skip person, then the transfer is subject to generation skipping transfer tax, which is imposed in addition to gift tax or estate tax. The reason there's a generation skipping transfer tax is to prevent individuals from avoiding estate tax on the skipped generation. Because the generation skipping transfer tax is a separate tax, you get a separate exemption. The exemption for generation skipping transfer tax purposes is $13,610,000 in 2024. Unlike the gift and estate tax exclusion, the GST tax exemption is not portable. Some key tax figures are adjusted each year for inflation, and you can see here how the exclusion and exemption amounts have changed. The Tax Cuts and Jobs Act, signed into law in December 2017, doubled the gift tax and estate exclusion amount and the GST tax exemption to $11,108,000 in 2018. The amounts are $12,920,000 in 2023, and as I mentioned, $13 million. But after 2025, they are scheduled to revert to pre-2018 levels and cut by about one half. So just understand that Uncle Sam's going to get theirs, and these numbers may change over the years. Over the last 20 plus years in business, I've seen them all the way to zero, all the way up to this $13,610,000. So just understand that if they need to raise more taxes, this estate tax maximum transfer amount may be changed and much lower. Making gifts during one's life is a common estate planning strategy that can also serve to minimize transfer taxes. In fact, transferring property to your heirs during your lifetime has certain advantages over waiting until you die. For one, when you make lifetime gifts, you have the satisfaction of seeing the recipients enjoy your gifts. For many people, though, gifting is used to minimize transfer taxes. As I mentioned earlier, one way to do this is to take advantage of the annual gift tax deduction, which lets you give up to $18,000 to as many individuals as you want, gift tax free in 2024. And there are several other gift tax exclusions and deductions that you can take advantage of. In addition, when you gift property that is expected to appreciate in value, you remove the future appreciation from the taxable estate. There's one trade-off to lifetime gifting, though. Generally, if you gift property during your life, your basis in the property for federal income tax purposes is carried over to the person who receives the gift tax. So if you give your $1 million home that you purchased for $50,000 to your brother, your $50,000 basis carries over to your brother. And if he sells the house immediately, income tax will be due on the resulting gain. In contrast, if you leave the property to your heirs at death, they get what's called stepped up or stepped down basis in the property equal to the property's fair market value at the time of your death. So if you own a home that you purchased at $50,000 is worth $1 million when you die, your heirs get the property with the basis of $1 million. If they sell the home right away for $1 million, they pay no federal income taxes. Remember that the annual gift tax exclusion lets you give $18,000 to as many individuals as you want gift tax free in 2024. If you and your spouse make gifts together, you can double that amount and give $36,000 to as many individuals as you want. If you're contributing to a child or grandchild Section 529 plan, a type of tax-deferred college savings plans, you can give up to $90,000 in 2024 gift tax-free, though you will have to report the gift over a period of 5 years. If you and your spouse contribute together, this amount can be $180,000 total. Certain conditions apply in each case. Be aware that if you should die during the 5-year period, a pro rata share of gift will be included in your estate tax purposes. Also, be aware that the $18,000 figure is indexed for inflation. This amount may rise or fall in future years. In addition, there's no gift tax imposed on any amount paid directly to an educational institution for an individual's tuition. There's also no gift tax imposed for any amounts paid directly to a medical care provider for an individual's medical care, including payments for health insurance premiums. So if you aren't inclined to make outright gifts, you might consider using a trust. A trust is a common and versatile estate planning tool. We've already seen that a trust can play a role in planning for incapacity and in avoiding probate. In addition, you may want to use a trust as part of an overall strategy to minimize transfer taxes, to have certain property managed by a professional, and to provide for minor children, elderly parents, and any other beneficiaries. And certain trusts can be established to protect your assets from future creditors. Most importantly, though, trust can provide a means to administer property on an ongoing basis according to your wishes, allowing you to maintain a degree of control after property is placed in the trust, even after your death. A trust is a legal entity where someone who's called a grantor arranges with another person who's called the trustee to hold property for the benefit of a third party who's called the beneficiary. The grantor names the beneficiary and the trustee and establishes the rules the trust must follow in a document known as the trust agreement. When you create a trust, you split the ownership of trust property. Legal ownership goes to the trustee, and beneficial ownership goes to the beneficiary. That means the trustee is legally responsible for managing the property according to the trust rules, and that the beneficiary receives the financial benefits such as income, principal, and the use of the enjoyment from the trust property. A trust that you create while you're alive is referred to as a living or inter vivos trust. A trust that is created upon your death, for example, under the terms of your will, is referred to as a testamentary trust. If you have the right to change and end the trust anytime you want to, the trust is described as a revocable trust. If the trust cannot be changed or revoked, the trust is described as an irrevocable trust. A revocable trust generally becomes irrevocable when you die, since you're no longer around to change or revoke it. While we won't go into great detail, revocable trusts are commonly used to plan for incapacity and avoid probate. A trust avoids probate because the trust agreement itself determines what happens to the trust property upon your death. Irrevocable trusts, on the other hand, are commonly used for transfer tax planning and creditor protection. Life insurance plays a part in almost everyone's estate plan one way or another. For example, if you otherwise have a small or modest estate, life insurance can be used to actually create an estate. In other words, the life insurance proceeds will be the primary financial resource for your surviving family members, at least until they are able to access the other financial resources. Life insurance can also be used to provide liquidity for your estate. That is, the life insurance proceeds will provide the cash your survivors need to pay final expenses, outstanding debts, and taxes. For example, you may have physical assets such as a home, retirement plan, and some investments that you do not want to be liquidated, but rather left intact for your surviving spouse. And life insurance can play many other roles as well, such as creating a bequest to charity or providing funds for your child's college education. You need to be aware, however, that the general rule is that life insurance proceeds will be included in your estate for estate tax purposes. Now, recall that in the beginning of this presentation, I made clear that we've also only talking about taxes in the federal level here, and that the situation may be different on the state level. Recall also that I said that $13,610,000 is effectively excluded from the estate tax in 2024. So if your total estate, including the proceeds from your life insurance, is equal to or less than the $13,610,000, you should have no worries. But if your total estate is more than that $13,610,000, then some of those life insurance proceeds may have to go to pay estate taxes. Although the general rule is that life insurance proceeds are included in your estate for estate tax purposes, an estate plan can be structured to exclude life insurance proceeds from your taxable estate. The key issue here is the ownership of the life insurance policy. A common strategy to avoid estate tax on life insurance uses a trust to own and hold the life insurance policy. Such a trust is commonly referred to as an irrevocable life insurance trust, or an ILIT. If the ILIT owns the life insurance policy, the proceeds of the policy will not be included in your estate for estate tax purposes. However, this is only true if the strategy is correctly implemented. Ultimately, you'll need to work with an experienced estate planning attorney on the strategy if it interests you. So let me give you the basic idea of how an ILIT can work. You create an irrevocable trust, name someone as the trustee, and name the beneficiary. The trustee buys a new life insurance policy on your life. The ILIT owns the policy. Then you make cash gifts to the ILIT, and the trustee notifies the beneficiaries as you make these cash gifts. And the beneficiaries have a limited window of time during which they have a technical right to withdraw your cash gifts, but they don't, since withdrawing the gifts would defeat the purpose of the trust. As the withdrawal periods elapse, The trustee uses the cash gifts to pay the premiums on the policy and the life insurance for the life insurance company. At your death, then, the ILIT receives the proceeds of the life insurance policy. If properly implemented, no estate taxes are due on the life insurance proceeds. And then the funds are distributed according to the terms of the trust. And the beneficiaries of the ILIT receive funds free from estate tax. Like most trusts, irrevocable life insurance trusts are more advanced estate planning strategy, and I've just attempted to give you the very basic understanding of how they might apply in your situation. If you're interested in learning more, I'd be happy to provide additional information. As we wrap up, take a moment and ask yourself these questions. Do I have a plan in place for incapacity? And do I have a will? If the answer to either of these is no, there's really no time to waste. You need to address these issues as soon as you can. Finally, even if you have an estate plan, does it reflect your current wishes and circumstances? Even if you have a current one, we always recommend that you should dust it off every 5 years or so and make any changes that are necessary. Small steps can help enhance your financial life one day at a time. And if you have any specific questions that you would like answered, you can email them to me at darren.royal@lpl.com or call me at 720. You can also take advantage of a 30-minute consultation where we can answer any specific questions you may have. You can book a time directly with me using the middle QR code here. To stay up to date on any additional educational opportunities, be sure to link to us on LinkedIn. And don't forget to check out our website. There you can learn more about Royal Wealth Management and sign up for any monthly newsletters. I appreciate your time today. That concludes our webinar today. If there's anything, like I said, you have any questions, please feel free to reach out.